everybody to the giant John Yoo debate. This is the third evening of Berkeley Says No to Torture Week. This is a week in which this community is standing up and saying with one voice, the torture, the rendition, the horrendous abuses that started especially being pulled together as a whole program under color of law during Bush and Cheney that continues now is totally illegitimate, it's immoral, it's illegal, it's inhumane, and it's got to stop. And we're here because every community in this country needs to do what we're doing and find their own way to do it, which is to say, we are not going to be silent in the face of this terrible evil. We are not going to be complicit. And we're here tonight at UC Berkeley because in this law school behind me, of which many of our esteemed guests and debaters tonight are alums, there is a war criminal on the faculty, and the law school administration and the chancellor have chosen to turn a blind eye to the problem of having a war criminal in the classroom teaching constitutional law to students who will be the next 40 years worth of lawyers and judges in this country. I'd like to bring up first the executive director and the founder of the Michael John Civil Liberties Institute. Please help me welcome Ann Fagan Ginger.
I got my Master of Laws here, so I came here and there was a man who was the dean named Frank Newman. And he believed that there was such a thing as the UN Charter and the various treaties, and he said that they were part of our law.
I'd like to bring up tonight's debate captain. Her name is Sharon Adams. She is an attorney in private practice. She is the chairperson of the local National Lawyer Guild's chapter of the Committee Against Torture. The way it's going to work is that we are going to have a projection of John Yoo. We've taken various clips of things that he has said, and we've tried to, be fair to his arguments and just allow him to present his arguments. And then we have a distinguished panel of debaters who are going to debate. We are going to have the projection of John Yoo up there, and I am going to start with Larry Everest.
I'm going without John Yoo.
Go ahead.
John isn't ready. It's funny, John never seems to want to debate anybody in person or apparently virtually tonight. So I watched the clip that they were going to show. It was shown on Democracy Now! It was John Yoo testifying before Congress on whether waterboarding constitutes cruel, unusual punishment and torture, and it was such a convoluted and complex discussion because John Yoo kept insisting that it was all a matter of interpretation. What does the UN Convention on Torture say constitutes torture? Any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person. Not very complex, pretty straightforward. Well, what is waterboarding? Waterboarding is not simulated drowning. Waterboarding is slow, controlled drowning in which water is forced down the throat into the lungs, and the person being tortured is only brought up at the brink, when they're on the brink of death. Does that sound cruel to anyone here?
My project in this book is to explain why, as a matter of the original understanding, things are not so clear. First, let me say that there's no clear text in the Constitution that explains how the war power process is supposed to work. So if you look at any other decision-making process that the Constitution sets out, where it wants the President and the Congress not only to agree, but to agree in certain stages, like passage of statutes or the making of a treaty or appointing of a Supreme Court justice, it usually says quite specifically that the President and the Congress and the President and the Senate must agree, and in what order they have to render their decisions.
Professor Yoo has a problem with interpreting the Constitution. So just to make this explicit, the Constitution in Article 1, Section 8, Clause 10, explicitly states the Congress shall have the power to make and declare war. That was an authority reserved to Congress with a great deal of intentionality by the founders. And let's just unpack exactly what went into that calculus. It's interesting when you note the context in which the revolution happened, right? The Constitution was written after a revolutionary struggle for independence from an unaccountable executive. The reason the executive power of the Constitution is spelled out in Article 2, thank you, and that Congress's power is spelled out in Article 1 is that Congress is the primary power in a democracy, right? Representatives in a democracy are where the government receives its legitimacy from. And so in the absence of representativity, a policy doesn't have legitimacy. And that was one of the reasons why the founders were very careful to reserve to Congress and not the president the authority to declare war.
When it comes to war, in contrast, you have a distribution of the powers. Congress has the bulk of them. They have the power to create a military and to raise the military, but the president has the commander-in-chief power. There's no there's no provision of the Constitution which sets out exactly how those are supposed to work.
Similarly, it is quite clear in the Constitution that the power to declare war is not the president's. It creates a range of problems against which our founders fought a revolution to gain independence. Commanders execute decisions from civilian policymakers. That's what distinguishes a democracy from a military dictatorship. The president's authority in the Constitution is never likened to that of Congress. It is a commander-in-chief authority. It's not the authority to declare war, it is the authority, as would befit the executive branch, to execute a great many things, including war.
The Philadelphia Convention debates do state that the power to declare war was given to Congress in order to limit executive power, or at least at least Congress had originally had the power to make war. That was changed to declare war, and that's quite true in the Philadelphia Convention. And people at the time thought that the president should not have the untrammeled power to make war.
I just want to say exactly. Johnny likes to talk about how he understands the original intent of the framers. Well, he just explained it to us. They said they wanted to limit the president's powers.
But I think the other piece of, and perhaps I think the more important piece of evidence to look at, is the debates that occurred during the ratification of the Constitution as it went from state to state. Those were the actual decisions that had the legal relevance in adopting the Constitution, not the Philadelphia Convention. And I think the most important convention was the Virginia Convention. If Virginia had not ratified the Constitution would have failed. There would be no states from which the presidents would have come from for the first 20 years of our country. So the Virginia Convention ratified the Constitution by only 188 to 180. And in that convention, Patrick Henry, fellows say, "Give me liberty or give me death," made a very strong case against the presidency, in much stronger terms than the ones I usually hear in Berkeley, mind you. And he claimed that the presidency would be a military dictatorship. And the very same James Madison, who Peter cited in the Philadelphia Convention, never said in that debate from Virginia that the declare war clause would prevent the president from seizing power because Congress had the power to control the beginning of war. Rather, he said that would work in the United States exactly the same way it worked in Britain. And in Britain, Parliament had controlled the president's power over war through the funding power. The Parliament had used its control over money to stop wars it didn't like and to encourage the king to go into wars that he didn't necessarily agree with.
Okay, so that's kind of a long and complicated argument, which John Yoo is really good for, but let's break it down. We don't want to look at what actually happened at the Constitutional Convention because that doesn't support John Yoo's view. What we have to do is go look at the debate that occurred in one particular state, Virginia, and then we have to look at the comments of one particular man, James Madison, and we sort of distort those comments because, as Shah had just pointed out earlier, James Madison was a strong proponent of the separation of powers. But somehow John Yoo finds from all of this that, I don't know, that the Congress doesn't have the right to declare war. I mean, that's what he does. He obfuscates, he sort of twists facts, he finds one fact that maybe supports his position, and then he puts that out as the law.
Think about it. He says Virginia. If the state of Virginia didn't ratify the Constitution, it wouldn't have been ratified. Well, you could pick 12 other states of which the same thing is equally true, right? Certainly the state of New York, which had a similar role with respect to being a behemoth, right? Which had a coalition of states behind it.
But they did.
So the idea of choosing a particular voice from a particular state convention as representative of a more legitimate critique or basis for assessment than the actual document that was passed is a bit aggrandizing to say the least. Don't forget also, Congress has attempted repeatedly to claw back its authority that has been usurped by the executive. In 1973, Congress passed the War Powers Act, which aimed precisely to address this question. In case there was any ambiguity after Vietnam, having seen what a president run amok could do, Congress acted, which it very rarely actually does, to stop this from happening. Nowhere in Professor's U does even a recognition of the War Powers Act emerge. It's interesting as well to compare the military structure between the executive and the legislature of Britain as a baseline against which to measure and extend the United States. Britain is not a standard at the time of the Revolution to indicate what the founders aimed to emulate. It is a standard to indicate what the founders fought a war to evade.
They were issued during this time period. They were never issued or understood to be the start of a war. Often, Great Britain, which was often at war in the 100 years leading up to the Constitution, declared war well after hostilities had started. In the United States, in the 7 years, in British North America, mind you, in the 7 years war, Great Britain declared war over a year after fighting broke out between Britain and France.
Why are we looking at what Great Britain did? We just had fought a war, a revolutionary war, to be free of them. So John Yoo is looking at what Great Britain did as an interpretation of how we should interpret our Constitution.
The Vietnam War is really when it became most prominent was does the president have the authority to use force abroad without Congress's authorization, without a declaration of war or any other kind of authorization? And you're right, I think what I had to argue was new in the sense that most legal scholars, and the prominent ones at this time, and probably continue to today still.
And Harold Coe is one of them.
Was probably one of the leading people in this takes this position, or the view that the president acts unconstitutionally unless he or she gets the permission of Congress through declaration of war or statute to wage a war abroad.
Well, John, you are a clever son of a gun. And I would like to make a proposal to the people who run this law school. Let's keep John Yoo up there on the wall permanently. Now, why do I say that? It's a little bit dark tonight, but when I came to law school here in 1967, I remember being quite taken by the two plaques that are on the wall there. And the one that John's right next to is a quotation from Oliver Wendell Holmes, who is regarded by many as being one of the most outstanding Chief Justices of the United States Supreme Court. And Holmes has a little bit different view of the law than John does. What Holmes says right up there, quoting Plato, I believe, is that the law is a princess, and that it stands everlastingly in the heavens as a fountain of justice and neutral application of principle. Now, John, you have a different view, buddy. You have a view, actually, which I agree with, because you don't think that the law is a princess. The legal system in this country, John, has one purpose, and that's to rationalize and maintain the status quo. And John, you are a perfect reflection of that and should be studied by all law students. So John, you are serving as a model for all of us. We now understand that the law is not a princess. We understand that the law is a tool of the establishment. And finally, we understand the truth of the principle, which I will leave you with, and that is, when tyranny is law, revolution is order. Thank you.